If defendant fails to report, I'll issue a bench warrant for his arrest without bond. Court calls the case of the people versus Rebecca Collins.
Once again, good morning, Your Honor. Assistant Public Defender Qasim Bobesi on behalf of Rebecca Collins. Ms. Collins, if you're there, could you please unmute and state your full name for the record?
She show up.
She is not here.
Yeah. Rebecca Collins, bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $10,000. I'll have a 10% privilege on that. That warrant will issue immediately, there being previous warrants. Court calls the case. People versus Jerry Doss.
Sylvana Reed, Assistant Public Defender with and on behalf of Mr. Doss. Mr. Doss, could you please state your name for the record?
Jerry Doss.
Thank you. Your Honor, unfortunately, I did not have good contact information for Mr. Doss, and given the recommendation, I would like to ask if it would be possible to adjourn his sentence so that I can get in contact with him and communicate what the recommendation is.
And Your Honor, Teresa Player on behalf of probation, I would just like to make the court aware, Mr. Doss is continuing to use drugs. He self-reported that he was continuing use of alcohol, marijuana, and crack cocaine up until May 13th. He was supposed to be going into treatment. He self-reported to me that he was kicked out of inpatient treatment at Higuera for selling his Suboxone medication. He denied doing that, however, was kicked out. He then was at the Home and New Vision Engagement Center when I completed the PSI. He was to enter Sacred Heart. He was supposed to provide me proof of entering that treatment. I did not receive that, and I was unable to be in contact with him. I later spoke with his parole agent, and his parole officer indicated to me that he was kicked out of that program or discharged due to not putting in any effort towards the treatment with that. He also tested positive for cocaine on June 5th when he reported to parole. Probation has concerns about Mr. Doss with the continued use and believes that some of these tactics with his treatment is to just keep himself out of jail.
In response to that.
None, Your Honor. Unfortunately, like I said, I was not able to reach Mr. Doss. Mr. Doss, do you have anything that you would like to state to the court?
I was moved from treatment because they didn't want me to do long treatment. They all they wanted me to do was come back to the community as Sacred Heart. I'm not what is safe leaving or something, where you just pay rent and and I told them I was trying to get to a long-term treatment, and they don't provide that. They just want to send me back to like a placement. And you just pay rent. So that was where the confusion came in. So, yes, I've been struggling with the addiction as well.
Given that report, I can either do one of two things. I can sentence him now, but if you wanted to talk to him in either event, well, you can do that, or I'm going to revoke the defendant's bond, order him to report to jail. So if you want to speak to him, that's fine, and I'll give you that opportunity. I'll adjourn his sentencing July 12th, 2023 at 9 a.m. Don't interrupt me.
Oh, yes,
at 9 a.m. Defendant's bond based upon the representation from probation and what he's been doing and the report in and of itself, and just looking at this. Defendant's bond at this time is revoked. Defendant to report to the Washtenaw County Jail by 6 p.m. today. To be held pending sentencing. If defendant fails to report, I'll issue a bench warrant for his arrest without bond.
Mr. Simpson. Your Honor,
Yes, sir.
can I get to in the morning so I can make arrangement with my
Be on that next one. Well, this one already had a warrant. Okay, got it. Be on that next.
That was
Court calls the case of the people versus Timothy Jessup.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Jessup. I do not see him logged in. Your Honor, if at all possible, could we briefly pass this and I can attempt to call him? I had a lengthy conversation with him yesterday and he was very much looking forward to discussing what's going on with him, with you. He wanted to give you an update, so I do not know why he is not present.
Well, why isn't he here? I mean, this was a 10 o'clock case. It's 11. Almost. Well, it's 10:38.
Yeah, I unfortunately do not know why he isn't here, but like I said, I did speak with him at length yesterday, and he had plans here.
Still don't have a report. Bench warrants will issue for defendant's failure to appear on these cases. Bond is set in the amount of $10,000, 10%. Warrants will issue immediately. Court calls the case people versus Samantha Jewell.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Jewell. Could you please state your name for the record?
Samantha
How
Jewell.
is this happening? Where are these coming out of?
I'm sorry.
Okay, she didn't appear. Why didn't she show up for her pre-sentence appointment?
Can I
Ma'am,
answer?
Yes.
Oh, okay. I'm sorry. I didn't, excuse me. I didn't show up because my phone was not on at the time. I didn't have the funds to pay my phone bill. So I missed the appointment and I do apologize for not reaching out sooner.
She was this one was put into a breakout room, wasn't she? And still didn't do it?
That is correct, Your Honor. I did speak with her yesterday. She was wanting to do the appointment yesterday. However, it was too late. So I told her to appear for court today.
Well, this doesn't bode well for what the sentence will be, but she better get there. We refer to defendant to probation for a PSI. You're to pay a $75 re-request. That is to be paid today. Set a new PSI appointment. That'd be June 20th, 2023 at 2 p.m. in person. You understand that, ma'am?
Yes, I understand. I did have a question. If I get paid on Friday, is there any way I can pay the 75 on Friday or does it need to be today?
It needs to be today.
Okay.
You should have been at your appointment. I'll
Okay.
adjourn the sentencing to July 12th, 2023, 9 a.m. Thank you. Court calls the case, People versus Matthew Brown.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Brown. Can you state your name for the record, sir?
Matthew Tyler Brown.
Thank you.
Teresa Clare on behalf of probation. Your Honor, Mr. Brown is before the court for a violation of probation. Mr. Brown is in violation of the terms ordered by the court in that he owes $1,695. His last payment to the court was in February of 2020. He failed to provide proof of any treatment to probation. He failed to attend AA meetings. He was ordered to attend 3 of those a week. He failed to report to probation as directed, failed to return a signed probation order, and he also has a new pending felony case, which is set for PCC tomorrow. Given all of the violations and his prior failures to appear for violation hearings, probation is recommending that Mr. Brown serve 365 days in jail, giving him credit for 15 days that he served to date to serve the balance, that he complete the in-jail Dawn Farm program, waive any remaining terms, accept his financial obligations, and discharge him from probation with improvement or without improvement. Sorry.
Response.
Your Honor, we did review that recommendation. All we would ask is that Mr. Brown have the possibility to be released after completing the Dawn Farm program.
I was told that this was getting adjourned and that I was going to be bonded over to circuit court and get drug court. I just spoke with an attorney this morning, and that
was probably in a different matter, Mr. Brown.
Okay.
Brown, anything you want to say? You admit to these violations, sir?
Your Honor, I've been clean and drug testing through Victory Clinic, and I have proof of drug testing for the past year. I would just like to say that I have been clean and that's about it. Yes.
But as to the violations, counsel, he admits to the violations.
That is correct.
All right. Sentence of the court, 365 days in jail, credit 15. Defendant is to serve the balance. He is to complete the Dawn Farm in jail program. Certainly you may petition the court for early release. I'm not making it part of my sentence that I will consider the release, but you could make a petition for release. He is to complete that Dawn Farm in jail program. Waive remaining terms, accept financial obligations, discharge him from probation, that is without improvement. Thank you. Court calls the case. People versus Shalitha Keith.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Keith. Ms. Keith, could you please state your name for the record?
Yes, Shalitha Keith.
Thank you. Your Honor, today is the date and time for sentencing in this matter. We did review the PSI report. There are just two corrections that my client would like to make. One, I believe the report mentioned that she had taken items previously from the store, and she wanted to indicate that that part was not true. And additionally, she was living in Ann Arbor at the time and not Ypsilanti. But other than those two items, everything else appears to be accurate. And we would just ask that probation's recommendation be adopted.
Ms. Keith, anything you want to tell the court?
Yes, that was just my first time. I just made poor choices. I was taking medication. Well, I'm still on medication and everything. And I'm currently not working because of the medication that I'm taking for anxiety and depression. But I just want to apologize for the wrongful decision that I made.
All right. Sent to the court. Place you on 6 months prosecutor deferred sentence. You're to pay $480 fines and court costs, $180 probation oversight fees. That is to be paid as directed by probation.
Okay.
There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to random testing as requested by probation. You're to complete a theft class. You're to do that within the next 60 days. You are to complete 25 hours of community service with proof to probation. There is no going to any Meijer store in the state of Michigan. I'll set a review hearing. That's to be held December 13, 2023 at 9 a.m. I'll order 90 days in jail. That is suspended. Thank you.
Okay. Thank you.
Court does call the case of the people versus Procopio. I think that's how I pronounce it. Vitale. I think I always mess up your first name. So
Procopio.
That's right. Okay.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Vitale. Mr. Vitale, could you state your first and last name for the record, please?
Yes, Procopio Vitale.
Thank you. Your Honor, we have reviewed the report in the recommendation. It coincides with what Mr. Vitale's plans are. The 365 days in custody, credit for 71 days, I believe, and then he is working on being released to treatment. He has been working with staff there at the jail. They are working on trying to find a facility for him. So he is making progress in that regard. So we would just ask that this recommendation be adopted.
And Teresa Player,
Oh, go ahead.
Your Honor, I just wanted to make the court aware that Mr. Vitale does have a pending felony case. Part of, I believe, the resolution with that case is that he complete residential treatment before he's sentenced. And I believe that that will likely be under a non-public with that case. And I believe that that period of time will be 3 years. So he will have supervision, probation supervision for some time.
Got it. All right. Mr. Vitale, anything you want to tell me?
Just apologize for, I found myself in a bad spot. I became homeless. So, yeah, I mean, no excuses. I'll just apologize for my actions. And no, it won't happen again. And I will complete the treatment.
Sentence of the court, $125 statutory fee. I'll order 365 days in jail, credit 71 served, defendant to serve the balance. However, the court will permit release to residential treatment. However, once you're in that residential treatment, if you fail to complete that treatment, then you have to return to the jail to serve the remainder of your sentence. You understand that, sir?
I do, Your Honor.
All right, very good. That's it. And good luck to you, Mr. Vitale.
Thank you, sir. And thank you, Silvana.
You're welcome. Good luck.
Court calls the case, People versus Anthony Mills.
Silvana Reed, Assistant Public Defender, on behalf of Mr. Mills, who does not appear to be signed in.
He is not checked in. Do you have any objection rather than issuing a bench warrant, given the recommendation to sentencing his presence if defense counsel is?
Yeah, I would agree with that. I did discuss this with him, so the only thing I can think is that because of the recommendation, he thought he didn't have to appear, but he understands what the recommendation is and is willing to accept that.
Sentence of the court, $125 statutory fee, 120 days in jail, credit 120, sir. Defendant is being sentenced in instead.
Thank you.
Court calls the case, People versus Christopher Minor.
Ready, Your Honor. Assistant Public Defender Qasim Bilbasi on behalf of Christopher Minor. Mr. Minor, if you're there, could you please unmute your microphone and state your full name for the record?
He is not checked in. And I think he was also sent there.
Yes, Your Honor. He failed to come in for his in-person PSI as the court instructed him to do.
The last time after I had adjourned it.
I had been unable to reach him, so I don't know.
Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000, 10%. That warrant will issue immediately. Court calls the case, People versus Even Shut.
Silvana Reed, Assistant Public Defender with and on behalf of Mr. Scott. Could you please unmute and state your name for the record, sir?
Evan Scott.
Thank you. Your Honor, we have reviewed the PSI report. We have no additions, deletions, or corrections, and just ask that probation's recommendation be adopted.
Sir, is there anything that you'd like to say before I impose sentence?
No, Your Honor.
All right. Sentence of the court, 6 months prosecutor deferred sentence program. You're to pay $480 fines and costs, $180 probation oversight fees. When can you get that paid?
Your Honor, I'd like to ask for a payment program, a quarter of it once a week for the next 4 weeks, starting a week from now.
So you can pay $150 next Friday?
Yes, Your Honor.
And then $150 each week after?
Yes, Your Honor.
$150 will be due by June 23rd, 2023. And then $150 each week until paid in full.
Thank you.
There's to be no use of alcohol, recreational marijuana, or illegal substance. You'll be subject to random testing as requested by probation. You're to complete a drug class. You're to do that within the next 60 days. No going to the Comfort Inn at 2376 Carpenter Road in Ann Arbor, Michigan. I'll set a review hearing that is to be held December 13th, 2023, 9 a.m. I'll order 90 days in jail that is suspended. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Damon Watson.
Ready, Your Honor. Assistant Public Defender Costin Bilbasi on behalf of Damon Watson. Mr. Watson, could you please unmute and state your full name for the record?
Damon Watson.
Yes, Your Honor. Today is the date and time set for a sentencing. We have had a chance to review the recommendation. Mr. Watson, did you have anything that you'd like to address on the report?
Nothing on the report, no.
We have no corrections, additions, or deletions at this time, Your Honor, so we would ask that the court adopt the recommendation of probation.
All right. Anything you or your client want to tell the court before I impose sentence?
No, nothing, Your Honor.
All right. The court does acknowledge this is not a serious misdemeanor as defined by statute. However, it does believe that there are reasonable grounds to depart from the presumption of a non-probationary sentence. Specifically, the alcohol screening assessment identifies the benefit of intensive outpatient treatment and attendance at AA meetings. Therefore, the court will follow the recommendation of probation of a probationary sentence with the stated rehabilitative goals to promote change, prevent recidivism, and to monitor compliance of recommended treatment. So therefore, the sentence of the court, I'm placing you on 12 months probation. You're to pay $1,055 fines and court costs, $100 prosecution recovery cost, $100 police agency recovery costs, and $360 probation oversight fees. When can you pay that, sir?
I know this is going to sound a little weird, but can I have until September 1st?
Do you have anything today?
I have not one single penny, sir. I'm sorry.
When can you make a first payment, Mr. Watson?
First payment I can have for you, not this Friday, but by next Friday.
By the 23rd, and how much will that be?
At least $100. I work a commission-based job, so it's kind of hard right now.
$100, June 23rd, 2023, and then a payment plan as arranged by probation.
That can be paid straight to the court on Washington.
Yes,
correct?
it needs to be paid to the court. Yes, sir. There is to be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to testing as directed by probation. You're to complete an intensive outpatient substance abuse program, including all recommended aftercare with status reports to probation. You're to attend 2 A meetings per week with monthly verification to probation. You're to provide proof of the victim's impeccable attendance at probation, or to probation, excuse me. You're to continue the scram for an additional 30 days in lieu of additional jail time. I'll order 180 days in jail, credit 3. The balance is suspended. Thank you.
Thank you, Your Honor.
Court calls the case, People versus Jessica Williams.
Silvana Reed, Assistant Public Defender with and on behalf of Ms. Williams. Ms. Williams, could you please unmute and state your name for the record?
Hi, Jessica Williams.
Thank you.
You're welcome.
I think we may want, there we go, to mute her so we don't hear my voice twice. This is the date and time for sentencing. In this matter, we have reviewed the PSI report, have no additions, deletions, or corrections, and would just ask that probation's recommendation be adopted in this matter.
All right. Ms. Williams, is there anything you want to tell me before I impose sentence? You'll have to unmute first. Did you say something? Because I couldn't hear you. No. It looked like you were telling me that you didn't have anything to tell me. Is that correct, ma'am?
That is correct.
Thank you. Sent to the court, $480 fines and court costs, 93 days in jail that is suspended. When can you get that paid, ma'am?
I can make a payment today. Do you guys take credit cards?
We do.
Okay. I can make a payment today.
How much?
I can make a half of the payment and pay the rest on Friday.
Okay, so you can make half of it today?
Yes, sir.
Okay, so pay $240 today, and then the balance you say you can pay by this Friday?
Yes, sir.
All right. And then I'll put the balance on the 16th. Okay. Thank you.
Although this hearing does not involve a sovereign citizen or jurisdiction-based legal arguments, it highlights an important principle that applies across the justice system. Court decisions are based on evidence, compliance, and credibility, not promises alone. In this case, the defendant had multiple opportunities to comply with probation conditions, complete treatment, and remain drug-free. Probation officers informed the court of continued drug use, failed treatment efforts, and missed requirements. Faced with that record, the judge concluded that another delay would not improve the situation. When the defendant requested until the following morning to prepare before reporting to jail, the judge explained that granting additional time could simply create another opportunity to avoid accountability, and therefore ordered him to report to jail that same evening. The hearing also demonstrates how judges evaluate a defendant's history rather than focusing on a single explanation offered in court. Repeated failures to appear, probation violations, and noncompliance often carry far more weight than last-minute assurances. The broader lesson is that courtroom outcomes are driven by documented conduct, prior compliance, and statutory authority. While rehabilitation remains an important goal, judges must also protect the integrity of the judicial process by enforcing court orders consistently. Accountability, preparation, and following court conditions remain the strongest path toward a more favorable outcome.